Good afternoon. Welcome to this Bar Standards Board's webinar about our consultation on transparency standards. My name's Vanessa Davis and I'm the Director General of the BSB. I'm joined this afternoon by BSB colleagues Ewan MacLeod, Director of Strategy and Policy, and Julia Whitting, who's our Supervision Manager. Let me just tell you what we're covering this afternoon. The webinar is a current consultation document which addresses some recommendations made by the Competition and Markets Authority. Ewan will give a presentation running through the consultation document. We'll then respond to the questions that you've already sent in or the questions you asked during the webinar. I'll say more about how to do that when we get there, but do add your questions as we go along. For those of you who are thinking of using this webinar as part of your CPD, we think that this webinar will help you develop how you work with clients to ensure transparency about instructions and fees and understand how these developments will affect your practice.
Okay, thank you, Vanessa. I want to start with a brief summary of the Competition and Markets Authority report and the various recommendations that it made. The headline finding was that competition in legal services is not working well for individual consumers and small businesses. In particular, not enough information is available to help people make the right choice, specifically with reference to price, quality, and service. The CMA pointed to research by the Legal Services Board showing wide variation in the cost for similar services and found that it was difficult for consumers to shop around and find the best value provider for them. And in a survey of consumers, they found that only around 1 in 5 compared providers before they chose one. So the CMA's recommendations included the following: a requirement for providers to display information on price, service, redress, and regulatory status to help potential clients. A revamping of the Legal Choices website. That's a website jointly produced by the legal regulators as a starting point for consumers who need legal help. Facilitating the development of intermediary and comparison tools. Encouraging providers to engage with client feedback and review platforms. And there were a number of recommendations to the government around reviewing the current regulatory structures, although it was noted that the current structures were not themselves a major barrier to competition. Our consultation focuses in particular on the transparency recommendations, and it runs until the 5th of January. It's the first of 2 consultations, so at this stage we're really open-minded and keen to hear what people think. Our aim is to find some practical things that we can do to improve the experience of clients when looking for a barrister. So focusing on the transparency recommendations, the overall aim of the CMA is to help consumers to compare providers. Now, we're not suggesting that barristers lack transparency at the point at which they accept instructions, and of course the BSB has some quite detailed rules setting out what information needs to be provided to the client at that point. But there does appear to be an information gap for people trying to find and compare providers. Not much information about price is displayed on Chambers websites, for example. We conducted our own research looking at Chambers websites and found that the vast majority, around 75%, publish nothing about fees online. And if that's the case, the only option is for consumers to contact individual chambers directly to ask for quotes. The premise behind the CMA recommendations and our consultation is that putting more information of the type that would routinely be included in client care letters into the public domain will help improve clients' experience and promote shopping around. Now, we obviously need to take account of the fact that most instructions come via solicitors, and we would expect solicitors to be better informed about the prices on offer. But we do still want to make sure that their clients can get the best deal, and I'll come back to that in relation to the scope of our proposals later. So turning now to how the recommendations will be implemented. We at the BSB have been working collaboratively with the other legal regulators in an implementation group. We have all published individual action plans, and we agree that there are benefits for consumers if we take a broadly consistent approach. But as the regulator of the bar, we need to be satisfied that what we are doing is the right thing for barristers' clients. And we also want to make sure we're not imposing unnecessary regulatory burdens, so proportionality is key. Which brings us on to the BSB's proposed approach. With proportionality in mind, we've reviewed and prioritised the CMA recommendations. And we're only proposing that what we've called very high impact recommendations should be mandatory at the bar. These are the things that we think will bring the greatest benefits to clients. And then this will be supplemented by guidance on the other recommendations. I'll summarise now what we think those very high impact recommendations are in relation to price, service and redress. In relation to price, we're proposing that the key information to be disclosed would be the charging model used, for example, whether fixed fees are used or hourly rates. We're not mandating a particular price model, but we think transparency about the type of model being used will be helpful for clients. In addition to that, additional indicative information will help potential clients to understand the likely cost. So if hourly rates are used, we would expect you to give indicative rates and how they might vary, for example, by type of case or by seniority of barrister. Where fixed fees are used, you could indicate what they might look like and the factors that will affect them. It's important to note that it will still be perfectly acceptable to have different rates for different types of work, or to offer deals to clients on a case-by-case basis. So to summarise what we're saying in relation to price, we're not proposing a one-size-fits-all model. Barristers could still charge different prices for different types of work. Fees information that's published only needs to be estimates, but we think that clarity on how fees might vary is key. Now, if you want to ask any questions on any of this, do submit a question in the box on your screen. But moving on for now to service. We think that the key information in relation to service should be a description of the services provided and indicative timescales and how they might vary. So we've given a relatively straightforward example here in relation to mediation, where you might say, for example, I can represent you in a mediation and help you to try to resolve your dispute. So that's a description of the type of service. And then you might give more information like, you will normally need to instruct me a certain number of weeks before the mediation, or a different number of weeks before if the mediation will be complex. We recognise, of course, that this kind of statement will be more complicated for other types of work. In fact, one of the things we want to do is talk to people in different practice areas so that we can give sensible examples across different areas of work. And we'll explore this in more detail in our next consultation. The next area we talk about is redress. And in relation to redress, we're also considering making some standard statements compulsory about the fact that barristers are regulated by the BSB and what the arrangements are in relation to complaints processes and the Ombudsman. There are In addition to that, some further proposals that we're consulting on. In relation to complaints data, we recognize that publication of complaints information could be confusing or misleading for clients, but we want to think about whether there might be a standardized way of reporting that could be useful. Would it also be useful for barristers to display the BSB logo so that clients can see easily who the regulator is? And in public access cases, should it be mandatory to provide clients with copies of the BSB's guidance for lay clients? The next thing we discuss is the scope of any new rules and who they should apply to. The rules that we envisage would only apply to the self-employed bar and BSB entities. Employed barristers may well be captured by the requirements of another regulator, for example, if they're working in an SRA authorised firm, and we think the issues are less relevant for those working in in-house practice. The CMA in its report has given particular priority to the public access bar. That feels right because of the direct interface that public access barristers have with clients. But the CMA also noted that there could be benefits of greater transparency in the referral sector, so we're asking about that too. Thinking about referral clients, our priority would be the more vulnerable or less knowledgeable clients. So we'd propose to link any duties to clients, any new duties to those clients who are entitled to complain to the legal ombudsman. In practice, though, we think that that would cover most people practicing at the bar to some extent. We're particularly interested to hear from solicitors also, to see if they would find greater transparency helpful for their clients. Now, as I said before, we're still at a very early stage in consulting about what form any new rules might take. But in this consultation, we discussed some different ways that we think people might comply with these new rules. We're broadly proposing two different ways of complying. Either individual information could be published about a specific barrister, or aggregate information could be published at chambers or entity level, or in fact a combination of the two. So for example, you might publish the most common types of case and how they tend to be priced depending on the level of seniority of a barrister, if it's being done at chambers level. The important thing is that we don't want to be too prescriptive because we recognize that a one-size-fits-all approach won't work. So alongside the consultation, we're also going to be testing the proposed new rules in a live trial. A number of chambers and entities are piloting the new disclosure requirements, and they will be publishing all of the proposed mandatory requirements on their websites, and a number of these have already gone live. I think 8 chambers and entities are already participating in this way, with another 5 or 6 hopefully joining in soon. And we expect to have a range of different types of chambers and entity, as well as a range of areas of law covered by the pilots. So turning to some of the other issues described in the CMA report, we've also set up a project to look at feedback. The CMA recommended that regulators should provide guidance to legal services providers on how to engage in collating online reviews and responding to comments publicly. And in the BSB's action plan, we've committed to publish guidance for providers on engaging with feedback, conducting research to establish the engagement of practitioners with online reviews, and as far as possible to align what we're doing with other regulators. What this means in practice is we've started a piece of work with the aim of improving the way in which barristers, chambers and entities gather feedback and how they make use of that to improve services to clients. It's envisaged that this will help consumers to make an informed decision about which barrister to instruct for their legal issue. thinking about the rules that we have in place at the moment, our handbook requires that the person responsible for complaints handling should prepare an annual report on the number of complaints received, outcomes, trends, and training issues. The BSB handbook focuses on complaints handling, but is silent at the moment on feedback, except in respect of barristers of less than 3 years standing who are undertaking public access work, although that's a rule that we're proposing to remove at the moment, and we want to look at how we can provide more generic guidance to the bar on seeking feedback from clients. Our supervision team has done some work on this already. So we looked at customer feedback mechanisms in chambers when we did the supervision returns in 2014 to 16. In practice, most chambers were able to describe some action taken as a result of complaints or feedback, even where complaints numbers were low. And we found that chambers took a range of approaches to obtaining feedback. In some cases, feedback was not proactively sought because it was felt that feedback was distracting, and clients who have lost their case might give disproportionately negative feedback. But there were a number of different ways in which other chambers did seek feedback. Sometimes that was informal, received through daily contact in the clerk's room or direct with a barrister, and this was often felt to be the most valuable source of feedback. Some chambers sent out routine requests for feedback at the conclusion of each case. Some received feedback at seminars for their professional clients. Some issued surveys to solicitors, although a number of chambers said that they struggled to get responses, and some solicitors weren't keen to receive that kind of survey. Practice review meetings with key professional clients was another mechanism that some chambers used, as was engaging consultants specifically to conduct client service reviews or making downloadable forms available on their websites. Not many chambers were actively seeking feedback from lay clients, and a number were telling us that it wouldn't be possible or appropriate to do that. So as part of this work going forwards, we're interested in hearing from you about how you gather feedback and how you get the lay client's perspective. And we're very keen to gather examples of good practice in addition to those that I've just shared. And if anyone does want to discuss feedback in more detail, then they're very welcome to contact our supervision team using the email address on the slide there. So before we move into questions, I'll briefly outline what the next steps are. So the consultation closes on the 5th of January. I've mentioned the pilot program, which will be ongoing for a while. Then once the consultation's closed, we'll obviously consider the responses to the consultation. As I've already said, this won't be the only consultation. There will be another one next year, taking into account the views expressed in response to this consultation, and drawing on the experiences of those who are undertaking the pilots. So the earliest point that any new rules could be agreed would be from around this time next year, and we would envisage any new rules taking effect from 2019. Again, if anyone has any questions, do send them in, and we'll try to answer as many as we can. And I'll now hand back to Vanessa.
Thank you very much, Ewan. So now it's over to you. But before we start taking questions, I'd like to take this opportunity publicly to thank those chambers that have participated in the pilot so far. It's very useful, and I'd like to thank them for their efforts on behalf of all of us, actually. So you can now ask questions of us and the BSB generally. You should see some website instructions there, but I understand there's a big purple Ask a Question button. You can simply type in your question. You can't see that purple Type a Question button if you're in full screen mode, however. I will moderate the questions. I may need to group topics, so questions that come in on a similar topic, I will try and group them together. Be assured that I will not identify you when I read back your question for everybody, and nobody else can see the question that you are asking. So do feel free to ask whatever you'd like to. We will not identify you as the source of the question. I hope very much that we'll be able to get through all the questions in the total of an hour that we've got available, but if for any reason we don't manage to get to your question, we will try to email you a response later this week. So the first one that I'd like to go to goes a little bit to one of your last slides, Ewan, and actually it's quite challenging. Let's take this one head on. This is a lot of nonsense, says our questioner. The CMA simply doesn't understand that the bar is a referral profession. What possible consumer benefit is there in our publishing our fees? Would you like to take that one, Ewan?
Yes, of course. I think, as I mentioned in the presentation, the CMA was aware that the bar is predominantly a referral profession, and they specifically referred to the public access bar in the report, and they felt that the benefits of transparency would be particularly relevant to those accessing the bar direct. But they also noted that there could be benefits in the referral context if there was greater transparency there as well. And that's partly why we've asked the question. We want to make sure that we're not excluding solicitors and their clients from any potential benefits here. But also, although we can see the logic in focusing on the public access bar, we need to make sure that we're not creating any unintended consequences. So if we apply new rules to the public access bar but not the referral bar, for example, does that make public access practice less attractive to barristers? And is it fair that one group of clients should benefit from the transparency requirements but not the other group? So we're really, we're still open-minded on that, but we're really keen to get the thoughts of anyone through responses to the consultation.
Thank you for that, Ewan. In some ways, that you've already answered a second question that's come in, which is the mirror image of the first one. Conceding that public access barristers deal directly with clients, but surely, therefore, our proposals should be restricted to them. I think you've pretty much covered that in what you just said.
Yeah, you can see a logical argument for saying that these proposals are more relevant for the public access bar, but we just need to be careful that we don't, by default, exclude any benefits that there could be for other clients as well.
So thank you for that, Ewan. I'm going to go to the next question that's come in, where somebody has asked us if we're able to say who the chambers participating in the pilot are. I suspect the specific answer to that is no, we can't do that publicly, but we can probably characterise them. What kind of breadth of practice areas and types of chambers have we got in the pilot?
Well, we've got a range of different areas of law covered. I think family law was particularly well represented in the group. In terms of types of chambers, we've got, again, a range of different sizes of chambers. We've got some entities that are relatively new taking part. And one of our other events like this, we had Stephen Ward from Clark's Room demonstrating what they're proposing to do. So Clark's Room is one of the participants in the pilot, and obviously they cover quite a wide range of public access practitioners.
It's perhaps worth mentioning there that we've had a lot of support from the LTMA, the Legal Practice Managers Association, and indeed the Institutes of Barristers Clerks, because I think we recognise as much as anybody else that critical to the success of these proposals, wherever they end up, will also be the people who have a key role in running chambers, not just the barristers who are affected. The next question that I've got is about fees and how they get set. And our questioner asks, I don't have a set fee for any work I do. My fees depend on a number of things, such as the nature of the case and the nature of the client. Why deny that flexibility, which surely benefits clients?
Well, it's a good question. We're not proposing that you would have to have one fee for all the work that you do. So it would be perfectly possible to publish different fees for different types of work, or even for different types of clients. And of course, there's nothing to stop you from offering a discount on your published rate to certain clients in any event. The problem identified by the CMA, I think, is that offering fees on a case-by-case basis means that some clients will find it more difficult to shop around, and that's really what we're trying to facilitate here.
So that's shopping around before So it's getting an idea of fees actually before you're instructed. So if it was me, I could ring up or see on a website several different propositions for the sorts of case that I had.
Absolutely.
Yeah, okay, I understand that. It's what I do with other services. So moving on then, there's some concern around what's going to happen if fees are out there, and a suggestion from one questioner that publishing fees would in fact be anti-competitive. The barristers would be under pressure to match the fees of the chambers next door, as it were, and they need to do that. Otherwise, if they look as though their fees are lower, their quality will be not so good. And our question says, look what happened with universities and tuition fees, where everybody went straight to the maximum fee possible, and there was no competition in relation to fees. What do we say to that? What does the CMA say to that?
Well, I think whatever we decide to do, we'll be monitoring the impact of any new rules, and importantly, so will the CMA. So if our proposals don't lead to better outcomes for clients, then obviously we'll need to review them. And the CMA will have the option of a further investigation into the market if it's not functioning well for consumers in a few years' time. I mean, at the extreme end, then collusion on price setting would be problematic and, in fact, illegal. So one of the things we're working on as part of this project is to produce some guidance for the bar on exactly what's permitted when publishing prices, particularly if it's done on a collective basis at chambers level, for example.
Yeah, I can see how that can be quite complex, particularly in the larger chambers. Isn't there also the other risk? And I've spotted a question here, which, if you like, goes to the other end of that argument. Publishing fees might simply result in a race to the bottom, with quality sacrificed on the altar of price competition. And that must surely be a worry, because clearly that wouldn't be in the consumer's interest, would it?
No, although I think that the CMA would say that a market that's working more competitively will generally be in clients' best interests. But I think it's important to say that price is not the only basis on which the bar can compete. And the CMA report makes clear that quality is also an important factor here. So we wouldn't expect that lowest common denominator of cheapest price only to be the way that this goes.
Okay, so I'm just going to add an observation here from a couple of the consultation roadshows that we've already run with the BSB across the circuits, and that's an observation around how barristers set prices in any event. And actually, there's this is a business skill, something that I know that some barristers have thought perhaps they would like to get more support from, and I think that the Bar Council may be thinking about ways in which it, working also with the LPMA and the IBC, could be supporting barristers with further guidance in relation to this, depending, of course, where these proposals end up. So
I think I would add in relation to that, we recognise that this isn't going to work on the ground unless we can draft our rules and provide supporting guidance in a way that's helpful for the profession. So we're really keen to work with the specialist bar associations, the Bar Council, LPMA, IBC, so that when we eventually get to publishing new rules and guidance, it's actually useful for people and has real-life examples of how you could go about implementing this.
Yes, and I know that those people amongst the regulators working on the Legal Choices website are particularly keen to make sure that the specialist examples are relevant and meaningful for different areas of practice, because there's a real recognition that every single case is different, and giving guidance needs to acknowledge that. So moving on, the next question we've got in here is about how easy it is already to get prices. And the questioner here says, you can get all the information about costs you need by simply phoning my clerk. Where's the benefit in having it all published online? Well, I know what I would feel if I was somebody who was trying to shop around. I'd much rather be sitting at home privately, just having a little look at what was out there, rather than having to pick up the phone, perhaps wasting my own time and phone calls because of not having had a different starting point. But what does the CMA think about this?
Well, I think that's exactly the point. So the benefit of having it online is that it makes it easier for clients to shop around. I think I mentioned earlier the statistic from the CMA report that 4 out of 5 clients don't talk to more than one provider. So making more information available up front will make comparison easier. And this is the kind of information that people will be routinely making available in their client care letters in any event. So I think what the CMA are keen to promote is that some of that information is brought forward and made publicly available rather than relying on a specific inquiry to a chambers for a specific piece of work.
I get that. Okay, moving on to the next question here. This is another quite challenging one, but it's one that we as the BSB absolutely must be prepared to answer, I think. It's why, the questioner says, why do you blindly assume that you must accept the CMA's recommendations? The Ministry of Justice doesn't seem to be able to be bothered to reply to the report, and they're already very late in doing so. So there's obviously no political pressure, and the CMA just don't know what they're talking about. Their report is really all about the solicitors' market.
Well, I think if you look at the CMA report as a whole, it really has looked in detail at the whole legal services sector from the perspective of the consumer interest and promoting competition in legal services. Now, irrespective of whether they looked in detail at what the bar does, these are two of our statutory regulatory objectives in any event. So it's obviously important that we, as the BSB, give the recommendations due consideration. And I think we agree that it would be in consumers' interests to have greater transparency of prices. The challenge for us is to find a way of getting more transparency in a way that's appropriate to how the bar practices. And as I said before, this is the kind of information that chambers will be used to making available to people. We're just trying to make more of it available up front rather than waiting for people to come and ask for quotes or and so on.
So the consultation and people responding to the consultation is really important in that respect. Julie, would you like to add something to that?
Yeah, so just from our the thematic review that we did on immigration, which some of you may be aware of, the themes around transparency of pricing and understanding how that relates to quality of services were really strong themes that came through from the work that we did, particularly speaking to consumer organisations. And speaking to barristers as well, who'd had to pick up the pieces from clients who'd come to them after seeking help in the unregulated market. A number of them were expressing the shock at the amounts that had been paid over, literally in bags of cash to unregulated providers, enormous amounts of money compared to what they themselves were charging on a public access basis. Or even on a referral basis from solicitors. So the lack of understanding amongst consumers in the immigration market as to what an appropriate price to pay for a service came through really strongly.
So that's a segment of the market, isn't it, where the consumers are particularly vulnerable. I mean, there's a related very vulnerable consumer area of the market, but it's a different kind of market, and it's one that was actually excluded from the CMA study, wasn't it? They specifically said that they didn't want to consider the publicly funded criminal justice system as part of the market. Does that mean, therefore, and we've got actually a question that relates to this a little bit, that these proposals are not going to apply to the criminal bar?
Well, we've taken a similar view in our consultation. So to the extent that criminal work is publicly funded, we don't think the recommendations are really relevant because clients won't be choosing their provider based on price there. But that's not to say that there might not be issues arising in relation to privately paying criminal work. And some of the other information in relation to redress and quality would still be relevant, irrespective of whether it was publicly funded.
Of course, but that's something, therefore, we're particularly grateful to receive views on. Let's move on a little bit to a slightly different area. We've got questions that I'm grouping together now in relation to this proposal or proposals around client feedback. And I think, Julia, you will be very well placed to answer some of these because you've been working specifically in that area. The first one is about consumers' capability to judge quality. And the questioner says several studies have shown clients can't really assess the quality of advice or indeed of advocacy. Generally, they're happy if they win the case and they're not happy if they lose the case. It doesn't mean to say that the barrister's got the price wrong. What do you say to that?
Yeah, I mean, this is a discussion we often have in the context of complaints, and as Ewan said, you know, we have rules around complaints. Barristers have obligations to have complaint procedures in place, and the argument there is often that, you know, barristers, consumers only complain when they've lost their case, and it's meaningless to look at statistics about complaints often because that doesn't tell you much. But I think most people now would say that that's not the case, and there is value in looking at patterns of complaints, and they do give you information, you know, regardless of whether the case has been lost or won. So, you know, I can understand it, and you know, it's a very different market to others where there's published feedback on online platforms, and perhaps people are more likely to give their feedback if they've lost a case. But I mean, you know, that's something that we want to look at and see whether that makes sense. I think there's value to be had in positive feedback, and there's value to be had in negative feedback. Just because one outweighs the other is probably not a reason to dismiss it.
I think I'd add to that, if I may, that the very fact that it's really hard for consumers, clients of advice and advocacy to judge the quality of what they're getting. It's what the Competition and Markets Authority called an information asymmetry, isn't it? The balance of power in relation to the information is very distorted in favour of the barrister. I guess that goes back to the arguments for having some of this explanation about what drives price, what drives complexity, and more hours to do the case out there on the website. If I understand their arguments correctly, Ewan, that's what they're saying, isn't it?
Yeah, and I think the point that Julia makes is a good one, that feedback needn't be a complaint. And I think you can get feedback at different stages in the client journey, if you like. So yes, at the end of the process, someone's feedback might be influenced by a negative result in their case, but prior to that, then there's still, you know, useful feedback that people can be providing, either positive or negative. And I think ultimately the professionals who reflect on client feedback and use that to inform their work going forwards are the ones who will be improving.
And that's certainly a lesson you get from other sectors as well. Julia, what were you going to add on that?
I was reading the Legal Ombudsman's recent report, and that was talking about the value of encouraging feedback, really to preempt complaints. So quite often, because there's such a clear process for complaining, because it's set out in regulations, you must have a complaints process. Quite often, clients want to give feedback. They don't really want to make a complaint out of it. They want to give feedback, positive or negative, but the negative feedback is not necessarily about slating the service. It's about something that could have gone better, and they just want to give a bit of feedback about it.
So that's preemptive, and actually could avoid one ending up with having to deal with a complaint from the legal ombudsman, which could save a lot of time and money. Thinking about the relationship between barristers and solicitors, obviously this is critical. We do questions here about the fact that, again, this notion that we only do referral work from solicitors. And the question is asking, are you saying that we should seek feedback directly, so barristers directly from the lay clients, but surely it's the solicitor that has that relationship and not the barrister? We should be making the solicitors do it for us. What do we say to that?
Yeah, I absolutely understand that. And we've had some really good discussions with clerks around this area. And as Ewan said, we know from the work that we've done in supervision, there are lots of different ways of getting feedback that are already in place in chambers and entities. And it's not necessarily about asking the lay client directly. It's about ensuring that the lay client's perspective is part of the discussions that you may be having with your solicitors. So, for example, when you have practice review meetings, what we found from talking to chambers was that the discussion is very often focused around the way that the service has operated from the solicitor's perspective and not necessarily from the lay client's perspective. So that's something that we're interested in exploring, how you get the lay client's perspective via the solicitor.
Thank you for that, Julia. We've got another question here that refers specifically to the lay client, slightly different though. This question says, we do commercial work and often don't even know who the lay client actually is. How can we ask them for feedback?
Yes, and I'm guessing that that's probably most likely to be the case in sort of large corporate commercial type work, where you may have less direct contact with the lay client. And as Ewan said earlier, that's not necessarily who the CMA are targeting in this piece of work. So it may well be that that's not relevant in that sort of large corporate type of work.
So this is the CMA's report then is indeed quite focused on consumers and small businesses. And is that contributing then to the suggestion that we've put out in the consultation document, Ewan, that actually the practitioners to whom these requirements will be made might simply be those where the client has legal ombudsman redress?
Yeah, so the CMA were focusing particularly on individual consumers and small businesses and their reports, and that broadly maps across to who's entitled to complain to the legal ombudsman. So, taking a risk-based approach as a regulator, you would expect us to target the areas of law that's most likely to be serving those types of clients. So people who have a kind of largely commercial type practice are not likely to be the ones that we're targeting here.
Okay, let's move on a little bit. Still broadly in the domain of feedback, but there's a few questions here that, if I can put it this way, suggest that perhaps we're trying to make a barrister version of TripAdvisor or something like that. So the question is, you're saying that we'll have to publish feedback on our website, but people won't trust it. Everybody knows that when you put feedback on a website, nobody believes it's real. And what's to stop people making exaggerated or false claims about feedback on their website? Julia, have we thought about that?
I think, yeah, it's interesting. This has come out in some of the roadshow discussions that we've had, and I think somebody said, that basically as a profession, barristers are not used to publishing feedback about themselves. And I know from some of the questions we get into the supervision team, we often get questions that they've spotted on a chamber's website or a barrister's personal website that they've made some grand claims about the quality of their services, and is the feedback genuine? And so, certainly anything published on the website has to abide by our handbook rules around what's marketed. But I think probably as a profession, barristers are not used to publishing feedback. I think that's certainly the case. And I think, back to what we were saying just now, positive feedback can be equally valuable as negative feedback. So positive feedback can give really valuable piece of information to a consumer who's potentially shopping around. I think as to whether, I think there is a certain amount of distrust when people see positive feedback on a website, because I think the market's just not used to doing it at the moment. But I think perhaps if more were doing it, it would feel less alien.
What do you think, Ewan?
Yeah, I mean, it's not unheard of for feedback to be published about barristers. If you look at the legal directories, for example, there are third parties who already provide that kind of thing. I mean, the way we think about it, it's not necessarily promoting things like TripAdvisor. I think we recognise that legal services are different, particularly at the bar, where services tend to be a bit less commoditised. So it's not like we're regulating conveyancing, where it's much easier to standardise the products that are being provided and therefore get more consistent feedback on them. And the number of individual consumers engaging with any individual barrister might be quite low, so that obviously has an impact on the reliability of TripAdvisor type approaches. But I wouldn't rule out the market evolving in such a way that there are some third-party providers who want to come in and collate more systematically feedback on a variety of different legal services providers. But I think we're probably trying to take a broader view, so it's not just about facilitating TripAdvisor style things, but looking more systematically at how barristers gather feedback and respond to it, and I think that's more likely to be the focus of the guidance that we produce.
Yeah, so we're not talking comparethemeerkat.com, we're talking some other kinds of online platforms, but one question has specifically asked us, which online platforms are you expecting us to use? You started to address that.
Well, yeah. I mean, we're not making any particular recommendations at this stage. We're keen to hear about what's going on out there and tailor our guidance accordingly. I mean, I think some in the legal sector are starting to engage with things like Trustpilot. I'm not really familiar with all the detail of how that works, but there might be a variety of ways of engaging with feedback from just consulting your own clients systematically, or engaging with these kind of third-party type things.
Okay. We're looking at the moment as to what's out there already and how they're being used, and so we're aware that there are comparison websites out there, perhaps for other sectors of the legal market, legal services market, but probably not being used so much by barristers. But we're looking to see what's out there at the moment.
Good, and presumably there's also models in other professional services sectors that one could look across that and take some lessons from, either about what to do or what not to do.
Yeah.
Good. Okay. Now I'm just looking up to my computer screen to see if there are any further questions from our audience. I think we have been through all of those that have been sent in. As I said at the beginning, if we weren't going to just string this out, everybody's got busy jobs to do. If you have a question subsequent to the webinar, do please email us. We'd be very pleased to try and answer your questions. Before we go, is there anything, Julia or Ewan, you would like to add that we haven't covered or that hasn't come out of the questions?
I don't think so. I would just reiterate that at this stage we are still very open-minded about what the rules might look like. We accept that there will be benefits for clients if we can introduce greater transparency, but we acknowledge there are challenges, and particularly where the services being offered are more bespoke in nature, then that provides some particular challenges in terms of the information that we put out there, and we obviously don't want to be requiring people to put out information that might be misleading or confusing for clients. So the information overload, I think, is as important to avoid as anything else. But we're just really keen to hear from people in responses to the consultation about how we can tailor these requirements to the type of work that's done at the bar, and kind of focus on what's possible maybe, rather than just some of the difficulties.
Anything else you'd like to add, Julia?
Well, just that the consultation doesn't cover feedback, so as was on the slide earlier, if you have any examples that you'd like to share with us, we'd be really keen to hear from you.
Good, well thank you very much for that. We'll go now to our very final slide, which is simply to say thank you to all those of you who've participated. If you'd like any more information about the consultation, there's an email you can write to. You'll also find the consultation document and other email contact addresses on our website. Consultation closes the beginning of January. We look forward very much to that point and hearing from as many of you as can respond. Can I simply wish you a very good afternoon? Thank you and goodbye.